Well, if I could have your attention, first I'd like to welcome everyone to this discussion, this roundtable on the subject of the Privileges and Immunities Clause of the 14th Amendment. I think most historians agree that the framers of the 14th Amendment regarded the Privileges or Immunities Clause as being the central and most important provision of the 14th Amendment. And yet, the ink was scarcely dry when, in the Slaughterhouse Cases, the Supreme Court interpreted the Privileges and Immunities Clause as applying only to rights already established under federal law, which, at least it seems to me and to many, rendered it a complete redundancy, because rights already established under federal law were already supreme under the Supremacy Clause, thus rendering this provision of the 14th Amendment largely a dead letter. There had been quite a revival of interest in the meaning and possible use of the clause a few years ago in connection with the case of McDonald versus City of Chicago. This is whether the newly recognized individual right to keep and bear arms that had been recognized against the federal government in the Heller decision would apply to states and local governments. And the principal plaintiff in that case was arguing not only that was so, that the Second Amendment rights applied as against state and local legislation, but also a much more radical theoretical point, which was that the proper vehicle, the proper textual home for the application of the Bill of Rights in general to state and local legislation is the Privileges and Immunities Clause of the 14th Amendment, rather than the Due Process Clause, which is what the Supreme Court has been saying for many years. And a number of amicus briefs were filed, and a lot of historians weighed in. But then, when the case was actually argued, Justice Scalia, the champion of originalist interpretation of the Constitution, dismissed the Privileges and Immunities argument as a mere academic matter, and only Clarence Thomas showed any interest in the subject as a practical matter. So you are now attending a roundtable on the most irrelevant question in all of constitutional law. Maybe I should say it's the most irrelevant, extremely important question in all of constitutional law. But if the court had taken the question seriously, they would have had to grapple with some really interesting and difficult problems of interpretation. And thus, for those of us who are interested in constitutional law as a matter of serious thought, the fact that the court is not interested gives us the opportunity to do it right, and to do it from a sort of unclouded by practical considerations. We can think about how the Constitution really should be read. And in this respect, the Privileges and Immunities Clause presents something of a puzzle, because although it's quite clear that the 14th Amendment says that no state shall make or enforce any law which abridges the privileges or immunities of citizens of the United States, what are the privileges and immunities of citizens of the United States? That's a difficult question, and there are at least two possible reference to that. The first, which seems most obvious from the text of the Constitution as a whole, is to the privileges or immunities protected by Article 4. Article 4 of the Constitution essentially requires each state to recognize the privileges or immunities of citizens of other states. So if you're a citizen of California and you happen to find yourself in Oregon, you're able to exercise the set of rights which are protected there. In other words, all each state may not treat the citizens of other states as if they were foreigners. You have the rights of citizens within those states. And these rights are sometimes given the term comity rights because each state extends them as a matter of constitutional comity to the citizens of other states. And it's, I think, pretty well accepted, although we may hear some disagreement about this, that these primarily are these are rights, for example, the rights of contract, property, and personal security. That if you go to Oregon, you can enter into, make and enforce contracts, you can buy, sell, lease, inherit, use property. You are entitled to all of the protections of person and property under tort and criminal law. So these are the basic set of rights, but with some, this I think will be the subject of some conversation, not political rights. I mean, you can't go to Oregon and vote in an Oregon election if you're a Californian. But you do exercise these other comity rights. Now, so one possible explanation of the 14th Amendment, which was that it requires each state to extend to all of its citizens this same set of comity rights. And we say all of its citizens, most pertinently, we're referring, of course, to the newly freed former slaves of the South. That the Privileges and Immunities Clause is essentially the most important part of the non-discrimination norm of the 14th Amendment, that states may not treat their own citizens, a group of their own citizens, as second-class citizens, as foreigners. So that's one possible referent. But there's another quite different referent, which is to the idea of the privileges and immunities of citizens of the United States might most naturally refer to the Bill of Rights, which is in fact a list of privileges and immunities that pertain to Americans as such. And so during the ratification, during the consideration in Congress of the 14th Amendment, not only the leading sponsor in both the House and the Senate and many other participants in the debate referred to the privileges and immunities in the 14th Amendment as involving the Bill of Rights, and thus saying that cases like Barron against Baltimore, that it held that these rights do not apply against state governments, would be changed by the 14th Amendment. So maybe this provision of the 14th Amendment refers to the Bill of Rights. Now that's a very different set of rights than the comity rights. So Bill of Rights are freedom of speech, assembly, press, religion, keep and bear arms, no quartering of soldiers in homes, Fourth Amendment protections against unreasonable searches and seizures, rights of property, jury trial, cruel and unusual punishment, and a whole panoply of criminal procedure protections. Very different set of rights. Right? So the question, at least one of the questions that our panelists are going to be talking about is how do we understand? What's the best way of making sense of this provision? Now, there may also be a third and a fourth and a fifth possible referent that we're going to hear. But I'm very proud to introduce the two speakers who are among the nation's finest constitutional historians. On my immediate left, Kurt Lash is the Alumni Distinguished Professor of Law at the University of Illinois College of Law. Kurt has written several very important books, including the Lost Ninth Amendment. He's written some of the extremely interesting pieces about the meaning of the change in meaning in the free exercise and establishment clauses between the Bill of Rights and the 14th Amendment. And now he is completing a new book on the on the Privileges and Immunities Clause entitled American Privileges and Immunities, Federalism, the 14th Amendment, and the Rights of American Citizenship. So Kurt will be speaking first, and then second is Professor Philip Hamburger, who is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. You may be the nation's greatest currently practicing American constitutional historian. His book, Separation of Church and State, has transformed many people's understanding of that, even the part that in which he and I have disagreed on many platforms. His more recent book, Law and Judicial Duty, is just a magnificent treatment of the nature of judicial responsibility, and particularly with respect to the question of judicial review. And I can't even mention all the various articles that Philip has done, but among them is some very thought-provoking work on the Privileges and Immunities Clause. So I welcome both of you, and Kurt, why don't you begin, and then Philip.
Thank you, Michael, and thanks to Professor McConnell and to Nathan Chapman and to the Stanford Center on Constitutional Law for putting on the event, and for giving me a chance to be on a panel with two such outstanding scholars. The three of us have been discussing the 14th Amendment for a long time, and I don't know if Michael remembers, but I actually called him as a law student years ago with questions about religious liberty and the 14th Amendment. And Philip and I have been exchanging, going back and forth on issues of 14th Amendment liberty all the way back to when you were working in D.C. And so this is wonderful. It's wonderful for us to be together in the same place to kind of share our respective journeys as we grapple with this sadly neglected and ill-used part of the Constitution. As Michael just laid out, I think that's exactly right. I think when it comes to the debate over the Privileges or Immunities Clause, there are two primary parameters to the debate. One, does it incorporate the Bill of Rights, or is it a mere equal protection kind of provision? And then secondly, if it does incorporate certain substantive rights, does it include more than just the Bill of Rights, but also protect a set of unenumerated substantive rights that the court identifies as requiring special protection? And just to lay out my bottom line at the beginning of the talk, I believe that the Privileges or Immunities Clause, properly understood, does bind the states to respect all enumerated rights in the Constitution. That would include the Bill of Rights. But it would not bind the states to protect unenumerated rights beyond providing due process protections and protection of under the Equal Protection Clause. So that puts me in the pro-incorporationist camp, but outside of the fundamental rights camp, reading of the 14th Amendment. And you might as well know that my reading of the Privileges or Immunities Clause has been considered the least persuasive reading available for some time, and it has the unfortunate effect of placing me alongside, at least to a degree, of placing me alongside of Justice Samuel Miller's opinion in the Slaughterhouse cases. Slaughterhouse, if you've taken constitutional law, you probably already know that Slaughterhouse is one of the most hated opinions ever issued by the Supreme Court of the United States. It's up there with Dred Scott and Lochner, maybe just a shade below those two, but not too far below. And one of the reasons why it's criticized is that it's generally viewed as the case which shut the door to the theory of reading the 14th Amendment as incorporating the Bill of Rights. Now, I don't share that reading. I don't think that Slaughterhouse closes the door at all. I don't think that issue was even before the court in Slaughterhouse. Instead, what Justice Miller did was simply distinguish the privileges and immunities protected under the Comity Clause of Article 4 from the privileges or immunities of citizens of the United States protected under the 14th Amendment to the Constitution. And according to Justice Miller, the latter, the protections under the 14th Amendment, did not include the unenumerated right to economic liberty, in that particular case, the right to pursue a trade. I think that Justice Miller was quite justified in reading the clause in a manner that distinguished its provisions from Article 4. And in fact, I think that when he distinguished between those two provisions, he was doing nothing other than following the same kind of understanding of the clause as that which was held by the man who actually drafted it, John Bingham, when he first put the clause together in the 39th Congress. So what I'd like to do in about 10 minutes or so, 10 or 12 minutes, is sort of lay out the theory of why I think John Bingham actually had the best reading of the clause that he had drafted. So I'll spend a little bit of time talking about privileges and immunities during the antebellum period, and then I'll just briefly talk about privileges and immunities at the time of the 14th Amendment. But I'll begin by talking about the Comity Clause of Article 4. This is one set of privileges and immunities that were discussed and enforced during the antebellum period. Now, the clause doesn't tell you what exactly the privileges and immunities are. It doesn't define who counts as a citizen who's going to be protected under the clause. But nevertheless, in a series of cases that began to be handed down really within a few years of the adoption of the Constitution, courts very quickly coalesced around a common reading of the general parameters of this particular clause, and they treated it like an equal protection clause along the lines of what Michael traced out in his introduction. Basically, it provided sojourning citizens equal access to a limited set of state-conferred rights. So if a state allowed their citizens to sell shoes, then if you're a visiting citizen from another state, well, then you would be allowed to sell shoes as well. This equal protection of state-conferred rights reading of the Comity Clause is reflected in decisions from early antebellum all the way up to the threshold of the Civil War. The same reading came down during the Civil War and in Supreme Court cases immediately after the Civil War. It was quite stable. And you can find the same description, this equal protection description of the clause in constitutional treatises that were written during the antebellum period of Kant's and Tucker's and Joseph Story's. So again, it was a very common understanding of the clause. It came under pressure, as did all constitutional provisions, due to the disputes over slavery. There was pressure on the court to maybe change or adjust its interpretation of the Comity Clause. So, for example, in a rather famous case that was decided just prior to the Civil War, the courts of New York had to decide whether or not privileges and immunities included the right of slave owners to carry their slaves through any state in the Union, both slave and free. What slave owners had argued is that privileges and immunities of citizens in the several states included the rights of chattel slavery, and therefore they should be protecting those rights wherever they went. The New York courts in Lemon against the People rejected that effort to try and transform the clause into a kind of fundamental rights of national citizenship reading, and instead they adopted the common interpretation, which was it protects only those rights, or gives you equal access only to those rights that we give our own citizens. And in the state of New York, we do not give our own citizens the right to own slaves. So that's the first category of privileges and immunities, those involving citizens in the several states under the Comity Clause. And again, I think that you'll find it's really a quite stable area of jurisprudence. The second strain, however, of privileges and immunities that were discussed during the antebellum period involved privileges and immunities of citizens of the United States, those rights which were common to American citizens as such. And you could see these described in different ways. They would talk about the rights of citizens of the United States, or the rights, advantages, and immunities of citizens of the United States, or the privileges and immunities of citizens of the United States. Those were all interchangeable terms. What distinguished this category involved whose rights we're talking about, and in this particular case, we're talking about the rights of national citizenship. During the antebellum period, you would commonly see these rights of American citizenship declared in United States treaties. So, for example, in the Louisiana Cession Act of 1803, it guaranteed to the inhabitants of the territory all the rights, advantages, and immunities of citizens of the United States once they became official members of the United States by way of entering as a state. This similar language in the Cession Act, the Louisiana Cession Act, can be found in many other treaties during the antebellum period. The Guadalupe Hidalgo, you find it in the Alaskan Cession Act, which was adopted by the 39th Congress, the same Congress that adopted the 14th Amendment. And these privileges and immunities, as declared in United States treaties, were different from the privileges and immunities that were protected under the Comity Clause. And the distinction was played out quite clearly in the debates over the admission of Missouri as a new state to the Union. Slave owners had argued that because Missouri was carved out of the Louisiana Cession, that meant that all the inhabitants of Missouri should get all the rights, advantages, and immunities of citizens of the United States, and that included, to slave owners, that included the right to carry slaves into any part of the Louisiana territory. In response, pro-freedom advocates like Daniel Webster replied by distinguishing rights, privileges, and immunities of citizens of the United States from privileges and immunities of citizens in the several states. According to Webster and others who are arguing along the same lines, privileges and immunities of citizens of the United States are those rights conferred by the federal Constitution. They are the rights which are common to all American citizens wherever they are, regardless of state law. They're quite different from the privileges and immunities that vary from state to state that would be given a degree of equal protection under the Comity Clause. So according to Webster, because slavery was a right that was conferred by different states, with some states allowing it and other states not allowing it, that meant it varied from place to place, and so therefore it could never be considered a privilege and immunity of citizens of the United States. And Webster's distinction prevailed at the time. Missouri is admitted as a slave state, but of course ultimately Congress bans slavery in the northern reaches of the Louisiana Territory. And this idea of privileges and immunities of citizens of the United States being described as referring to a category of rights conferred by the Constitution can be found in a number of places during the antebellum period, not just during major political disputes like you get in the Missouri debate. You can find the Attorney General of the Jackson administration drafting reports talking about how citizens of Arkansas, because Arkansas was also taken out of the Louisiana Territory, the inhabitants of Arkansas, as they were seeking admission, enjoyed all the rights, advantages, and privileges of citizens of the United States, and that included the right to peacefully assemble and to petition government for redress of grievances. And according to the Attorney General, the reason they get those is because those are, quote, among the privileges and immunities of citizens of the United States. Okay. So in sum, as you're approaching the 14th Amendment period, you can identify in political and legal rhetoric in the antebellum period two different strains of privileges and immunities, one involving those rights conferred by states that get that equal protection under the Comity Clause, but then a different category of privileges or immunities which are conferred by the federal Constitution and which are common to all. So now the question becomes, did that distinction play a role in the drafting and the original understanding of the 14th Amendment? Well, in some ways, at this point, I would simply point to the text. I think there's some clues in the text itself. It doesn't use the language of state citizenship that you would find in Article 4. Instead, it uses the language of national citizenship of the kind that you would have found in United States treaties. But even going beyond the specific text itself, when you look at the historical record, there's abundant evidence that, in fact, it did reflect this distinction between Article 4 rights and the rights of American citizens as such. It's helpful here to understand that there were two drafts of the 14th Amendment. Both were written by John Bingham, and both were discussed in the 39th Congress. The first draft by John Bingham used the language of Article 4. That was discussed, debated, criticized, and rejected. Then, a little while later, he came back with a second draft. That second draft abandoned the language of Article 4 and instead used the language of United States treaties. Now, the reason why Bingham gave up on his first draft of the 14th Amendment and changed the language and then adopted the language of American or national citizenship is a subject I go into fairly detailed analysis in my article and even more detailed analysis as I'm working on the book. But just in brief, it's clear from Bingham's speeches both before the Civil War and after the Civil War that one of his primary goals was to require the states to protect the rights listed in the Bill of Rights, particularly listed in the first eight amendments. When he drafted the 14th Amendment for the first time, he believed he could accomplish that goal by way of the language of Article 4. He had a very idiosyncratic reading of Article 4. He read it with an additional ellipsis, and he would say that it protected the rights of citizens, ellipsis, of the United States, in the United States, and believing that it referred to the rights of American citizens as such, he believed that it obligated the states to protect all of those rights that were conferred by the federal Constitution, and to Bingham that meant the Bill of Rights. But the problem was the draft that he produced his first time out just used the language of Article 4. So when it was first discussed in the 39th Congress, his colleagues believed that all he was trying to do was to give Congress power to enforce Article 4. And that's how they responded to his draft. That isn't what Bingham wanted to do. He wanted to go much further than simply provide equal protection rights. According to Bingham, the ability to enforce the Bill of Rights is the want of the Republic. It was a singular goal for Bingham, or one of his major goals. So when he realized it wasn't accomplishing what he had hoped it would accomplish, he withdrew the amendment himself. And then sometime later, he came back with what we know as the second and final draft of the 14th Amendment. This time he used the language not of Article 4, he had abandoned it at that point, and now used language that was familiar with the United States treaties, including the treaties that the 39th Congress adopted itself with the Alaskan Election Cession Act. According to Jacob Howard, the man who introduced Bingham's amendment in the Senate, the Privileges or Immunities Clause not only required states to protect the equality norms of Article 4, but it also obligated the states to respect, quote, the personal rights guaranteed and secured by the first 8 amendments to the Constitution. All right, in conclusion, I don't think it's any accident that Bingham dropped the language of Article 4 and instead adopted the language which was common to United States treaties. That language would have helped accomplish what Bingham's goal had been all along, and that was to get the states to enforce and protect the personal rights which were conferred by the Constitution itself. And that's all he wanted it to do. According to Bingham, it had that effect and no more. He did not want to give Congress general jurisdiction over the entire subject of civil rights in the states. He simply wanted them to protect those rights which had been in the Constitution all along. One final point. The evidence that I've used thus far has focused on antebellum discussions of privileges and immunities and discussions in the 39th Congress. I've not talked about any post-adoption discussions of the 14th Amendment. Now, there are reasons for this, and I presume that we're going to have a conversation in that direction, but post-adoption discussions are often pushed back and forth due to later political considerations, and they may or may not be reflective of original understanding. But if, as we go forward, it becomes important to address post-adoption commentary, I'll be happy to do so, including an 1871 speech by John Bingham in which he expressly adopts exactly the theory that I presented here today. So in sum, as uncomfortable as I might be being alongside Justice Miller in the Slaughterhouse cases, I really think he was onto something. He was onto a distinction that was adopted by the man who drafted Section 1 himself, John Bingham. Thank you.
Well, it is a great honor to be here with all of you, and especially with Kurt and Mike. Thank you for coming and for having me here. So, it's a tough question. Did the 14th Amendment's Privilege or Immunities Clause really incorporate the Bill of Rights? And if not, which will be my second question, what on earth did it do? Now, almost all legal academics are true believers. They believe in incorporation. The literature has phrases like everyone agrees, and it's a scholarly consensus. That just rubs me the wrong way. But that's not the only reason I'm taking this position, but it's a first step to distrust. So is it true? And how would one know? The answer surely rests in the evidence. And that's what I'd like to run through today. I'd like to start with the first question. Did the Privileges or Immunities Clause incorporate the Bill of Rights? And it seems to me one can run through a series of types of evidence: the text, the debates, and the underlying controversy. So let's just start with the text and see if perhaps we can find anything there about incorporation. The 14th Amendment says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Could this have incorporated the Bill of Rights? Well, there's a problem, and the problem is with the word citizens. The clause is surrounded by other clauses that speak of persons. All persons born or naturalized in the U.S., etc., are citizens of the U.S. Evidently, citizens are a subset of persons, and that's clear even from the text. It continues after the Privileges or Immunities Clause, nor shall any state deprive any person of life, liberty, or property without due process, nor deny to any person within its jurisdiction equal protection of the laws. Now, note that the Bill of Rights guarantees the rights of persons, not generally citizens. It's key. These are the rights of persons. So if the Privileges or Immunities Clause incorporated the Bill of Rights, it would have to say something like, no state shall deny to any person in the United States the rights that the United States owes to persons within its jurisdiction, or something along those lines. So why only citizens? Why confine this supposedly this expansive clause to mere citizens? Perhaps it was to deny incorporation to visiting aliens. Well, but there's no evidence of that. That would be just bizarre, right, and contrary to all U.S. policy. Perhaps it was a mistake. They just goofed up in that section. Said citizen, but it meant person. But of course, it was very deliberately drafted, as clear from the Citizenship Clause. They were paying attention to the difference between citizen and person. In fact, the privileges and immunities of U.S. citizens were very different from the rights of U.S. citizens. The phrases refer to different sets of rights. And this is why Bingham, in the debates, and indeed in earlier debates in 1850, always distinguished between the privileges and immunities of citizens and the rights of persons. The text, therefore, does not suggest incorporation of the Bill of Rights. Indeed, by guaranteeing the privileges and immunities of citizens, the text appears to be referring to another set of rights. Okay, so the text didn't get us to incorporation, but let's give it the benefit of the doubt. Let's look at the debates, because perhaps intent can trump a text and help us along somehow. Well, the framing and ratifying debates do refer to the Bill of Rights, no doubt about that. But the centrally quoted passages by Bingham and Howard actually don't speak of incorporation, let alone to the Privileges and Immunities Clause. When we read them carefully, it turns out Bingham is saying that rights in the Bill of Rights would be protected by the Equal Protection Clause. That's odd, isn't it? It's not even our modern Supreme Court's version, which is the Due Process Clause. Howard says that the Bill of Rights would be protected by the first section of the amendment, meaning all three of those guarantees. In other words, equal protection, due process, and privileges and immunities would have the effect of securing basic liberties, not understood as the set of guarantees written out in the Bill of Rights, but as the more general rights or concepts of rights that are protected in various written documents. We would get the effect of protection of these through some combination of the guarantees in the 14th Amendment. Indeed, the debates contain statements that clearly preclude incorporation. Incorporationists don't tend to pay attention to these, but it's worth lingering on them to realize there's a problem here. Bingham, speaking of the Privileges and Immunities Clause, says it's that part of the amendment which seeks the enforcement of the second section of the fourth article of the Constitution, in other words, the Comity Clause. He's very blunt about that. Howard says about the clause, it relates to the privileges and immunities of citizens of the U.S. as such, as distinguished from all persons not citizens of the U.S. And again, that's getting back to their standard distinction between persons and citizens, the privileges and immunities versus the rights of each. So the debates have problems, obstacles to an incorporation thesis. What about the underlying controversy? Perhaps we can rescue the incorporation position there. Constitutional amendments don't just come out of nowhere. They're not literary creations done by an author scribbling in a garret. These come out of national controversies, and the 14th Amendment arose from profound such controversy, one that tears the nation apart. And it was talked about endlessly, of course, in newspapers and pamphlets and sermons. So was there such a controversy about incorporation? For example, was incorporation debated in public rallies? Was it debated in churches or town meetings? No. Not at least unless it was discussed in code and we just can't read it, right? The oceans of 19th century newspapers survive. I haven't seen this debate, national passionate debate about incorporation. Was it the subject of congressional resolutions that almost divide the nation and sunder it? It's in 1820. No. So who was demanding incorporation in the 1830s and 40s and 50s? Well, one gentleman that's proposed as an advocate of incorporation who did advocate it was Joel Tiffany in Ohio. Who was he? He was an obscure Ohio lawyer. He had some prominence in his own little county, admittedly, but he was an obscure Ohio lawyer known best as a spiritualist. And in fact, the newspaper accounts of him from the time generally concern his spiritualist rantings in local meeting houses. That's reported in Ohio newspapers. That's very nice, but it's not exactly a national debate. He reaches national prominence when he writes his tract advocating incorporation, and the national prominence consists of an entry this big in one DC newspaper which notes that he's written a pamphlet. This does not constitute a national debate or controversy. It's sometimes said that northern abolitionists in southern states demand the privileges and immunities of citizens of the United States, and Akhil Amar has said that this shows they're seeking incorporation. But in fact, they never said that. In fact, they're only claiming comedy clause rights. The northerners in a southern state deny the free speech. They seek comedy clause rights. So incorporation does not seem to be a central anti-slavery demand in the evidence seen thus far. In fact, of course, slaves don't need incorporation of federal rights. What they need are federal guarantees of equality in state rights. That's the central issue. And it's therefore no surprise that incorporation is not very prominent in all of this. In short, the text conflicts with the incorporation thesis. The debates also have elements that conflict with it. And there's no underlying controversy of the sort one would expect to give rise to an amendment. Okay, so let's start all over again. Let's just clear the table of this incorporation stuff and start afresh and try to figure out what's going on. And this leads to a second question. If it's not incorporation, what is it about? We've already seen hints about the comedy clause, but that already should puzzle us. Why repeat a clause that's already in the Constitution? Why repeat it in language that's slightly different about US citizens rather than state citizens? That doesn't make sense. And frankly, why would anyone care? Really, why are you going to care about this technical clause in 1866 when they're trying to put to rest the conflict over slavery? This is my version of PowerPoint that's slowly moving across the room, and I suppose I should share it with my colleagues here. We'll get to it shortly. So this time I want to work through the evidence in the other direction. Not in reverse, not backwards in time, but forward. I want to start with underlying controversy and then just look at the debates and the text. So it turns out there was an underlying controversy about the comedy clause. We're all familiar with the problem of intrastate discrimination. That's what we talk about in terms of equal protection and due process. But those terms don't actually apply to another aspect of the problem, which was the interstate discrimination. Interstate inequality has been largely forgotten in the anti-slavery controversy, but it's worth lingering on, and it had a slightly different vocabulary. The comedy clause says citizens of each state shall be entitled to all the privileges and immunities of citizens in several states. It gives equality to visiting outsiders, and in this sense, note the sociological character of it. It's a response to modernization. Think of modernity as a product of mobility and communication that tears apart older communities and their prejudices and creates a more cosmopolitan community layered on top. The comedy clause was designed to protect this. However, it breaks down under racial prejudice. The early comedy clause disputes in the nation about white mobility, whites going from one state to another. And in those disputes, there was no question of who has protection, but just what is your protection? What rights are protected? And that's the nature of all these early comedy clause decisions, except one involving Tories in the 1780s. But generally, that's the extent of it. And incorporationists tend to focus on this. Of course, there's a corporation, which rights were included. Black mobility, however, was increasingly prevalent in the early 19th century. We're not talking about we're not talking here just about slaves being brought from one state to another, the standard study, but free blacks moving across the United States. And that shifts the debate to who is protected. And this is what leads to the Privileges or Immunities Clause. Of course, Comedy Clause rights were already protected in 1866, but that doesn't mean they're already enjoyed. So this dispute, I won't go through all the details. I can bore you in great detail if you want, though. But this dispute rages from 1821 through 1866. It begins in 1821, the Second Missouri Compromise. Missouri seeks to exclude freebacks from entering the state. It continues in lower court cases from 1821 onwards. The Missouri Compromise triggers a series of Southern cases on this, including Corfield versus Coryell, which I'll get back to. And then it becomes central again in 1857 in Dred Scott. A large part of Dred Scott is not very indirectly about this question. Although it's decided on a diversity question, it's really about the substantive question of the Comedy Clause and its application to free blacks. The Southern interpretation had two elements. First, Comedy Clause rights belong only to citizens of the United States. You see, many free blacks were citizens of their states, so it wouldn't do for the South to say it belongs to citizens of the states. So they take a national position. And then second, the Southerners say free blacks are not citizens of the United States, and they therefore cannot have the benefit of the Comedy Clause. And the Southerners prove this by saying the Comedy Clause protects political rights. You see, if the Comedy Clause protects rights to vote and hold office, then it seems to them clear that this could not have been intended to extend to free blacks. That would be inconceivable, they say. And so the expansion of the rights covered, of what is covered, is designed to deny access. The Northern response actually accepts the first proposition. Northerners accept Comedy Clause rights belong only to U.S. citizens. Northerners like this because that becomes a justification for congressional enforcement. But then they answer second, free blacks are U.S. citizens, and they therefore are protected by the Comedy Clause. Corfield and Dred Scott both established the Southern interpretation. Corfield's usually assumed to be unrelated to race. It's an anodyne decision about what rights are protected. It's merely technical, and this simply washes color out of the case. Bushrod Washington was a distinctively harsh slave-owning Southerner. I can talk about that in more detail. There are very sad elements to all of this, and involves the estate of George Washington, where he had a role. The case concerned whites, New Jersey oysters and whites, and therefore it's on what rights, not whose rights. But when listing the privileges and immunities, Washington plays a game. He accepts the right to travel, thus accepting the position of Congress in 1821 against Missouri, saying that there's a right to travel, the Privileges and Immunities Clause. But he says the Comedy Clause protected fundamental rights, including suffrage. This is the standard Southern way of saying blacks are not included. And everybody must have known it at the time. And you can trace this doctrine in other cases. He's, in a sense, just following a series of other Southern cases. Dred Scott really echoes this, and when Taney denies that free blacks can be citizens and therefore don't have Comedy Clause rights. So on the eve of the Civil War, there's a national controversy about the Comedy Clause, and it's all about who, not what. Who's included? Obviously not blacks from the Southern point of view. And this shows why one needed a clause, in a sense reaffirming a clause already in the Constitution, because blacks didn't have the benefit of it. Now, this gets interesting and more engaged with what we were discussing earlier, because the controversy also shows why the 14th Amendment spoke in terms of privileges and immunities of citizens of the United States, not citizens in the several states. This was the label for the Northern interpretation. So Kurt asks, what do these particular words mean? What does privileges mean? What does immunities mean? And I agree. These mean rights, no doubt about that. To this end, he examined session treaties to discover the technical meaning of the words. But my fear, and it's an interesting move, and no one's done this before, and it's admirable, my fear is that it reduces the 14th Amendment's phrase to its words, and that it denies its political context, and it denies its racial context. And that perhaps is a bit of a problem, because this was all about race and politics. There isn't a stable privileges and immunities. This is disputed North and South. The Comedy Clause interpretation was the center of the racial conflict, and this reveals that privileges and immunities of citizens of the United States was the Northern label. So, for example, Oregon in 1858 submits a constitution echoing the Missouri one in 1821, and the Constitution excludes free blacks. Bingham stands up and defends the Comedy Clause rights of free blacks and as the privileges and immunities of citizens of the United States. This is a succinct way of capturing the Northern position, because the Northern position is, this is indeed a right that belongs to citizens of the United States, but blacks are citizens. And so you encapsulate your whole argument in the label. In sum, there is, I actually just want to mention one more thing. Northerners rewrite the clause, as Kurt noted. It's not just Bingham. A whole slew of Northerners regularly rewrite the clause, and what they do is they insert citizen of the United States after citizens in the Comedy Clause. And what they're doing is interpreting it by rewriting it. So in short, there was no national controversy over incorporation, but there was one over the Comedy Clause, and the 14th Amendment is designed to resolve that interpretation dispute. Okay, very quickly, if I have time, a few more minutes, I'd like to talk about the debates and the drafting. I've already mentioned that the congressmen say the Privileges and Immunities Clause concerned the Comedy Clause. That's what it related to. The drafting confirms this. Kurt aptly and grateful described the two drafts, right? Why did it shift from one draft, which is just in terms of the Comedy Clause and citizenship of the states, why did that then turn up into a phrase about citizenship of the United States over the course of 2 months? Well, there's nothing in the debates really explaining this very directly. Was this a change of meaning or just a phrasing? And what was the meaning of privileges and immunities of citizens of the U.S.? The answer comes in the document that I've distributed. This is a bill to declare and protect all the privileges and immunities of citizens of the United States. This bill does not turn up in the extensive scholarship, but it's sitting there on the Library of Congress website if you're interested. This bill was introduced in between the two drafts precisely to protect the Comedy Clause rights of free blacks in the familiar Northern slogan. The slogan gives us the title there. And that title, to protect privileges and immunities of citizens of the United States, then becomes what Bingham redrafts the 14th Amendment in terms of. And it wasn't just from this bill. It was a phrase Bingham and many others had used when arguing for the Northern interpretation of the Commerce Clause. And he's sort of spurred to do this because when his friend Schallenberger introduces this bill. And then what about the text? So if the drafting shows the 14th Amendment echoed the underlying Comedy Clause controversy, what about the text? Well, the text simply settled that controversy in terms of the Northern interpretation of the Comedy Clause using the Northern label for that interpretation. And to protect against Southern evasion, later there's added a definition of citizenship to make clear that Southerners can't say, oh yeah, but still blacks aren't citizens. And this, by the way, is interesting not just for our conversation, it's interesting structurally. What's the structure of those three clauses of the first section of the 14th Amendment? The Due Process and Equal Protection Clauses deal with intra-state discrimination within a state, by a state. That comes out of the Civil Rights Act of 1866, which was thought to be unconstitutional. The Privileges or Immunities Clause deals with interstate discrimination. In that sense, it echoes the Privileges or Immunities Bill that Schallenberger introduced. So just to conclude, the Privileges and Immunities Clause does not incorporate the Bill of Rights, and I think this is evident from the text, from the debates, and from the underlying national controversy, or lack of it. Instead, the clause reaffirms the Comedy Clause in terms of U.S. citizenship, in other words, in terms of the Northern label for the Northern interpretation of it. Thank you.
So I'd like to just very briefly present a third context, which is a bit different from both. I agree with Philip that we need to keep our eye on what the national controversies were, but much of what I'm not going to say that what he said is not a big part of that, but the larger national controversy, right after the adoption of the 13th Amendment outlawing slavery, was that the southern states enacted what were called black codes, which were legislative attempts to come as close as they could to restoring the circumstances of slavery without actually having the ownership of persons in chattel slavery. And so what these laws did was that they prohibited black persons from making contracts, from being able to enforce their rights in court, from being able to own property, from being able to, they subjected them to different criminal penalties and to different standards of tort law. Congress responded to these black codes by the enactment of the Civil Rights Act of 1866, which stated that no state could deny to any citizen on the basis of race, color, or previous condition of slavery the rights enjoyed by white citizens too, and then there's a list of rights. They are basically to sue and be sued, to enter into and enforce contracts, to own property, to the equal rights of personal security. Now that list of rights, that's directly responsive to the black codes and essentially makes them illegal, but it is also a list that is substantially identical to the comity rights that have been recognized for citizens citizens of one state when they would go into another state under the Comity Clause of Article 4. There's substantial disagreement over whether the 66 Act is constitutional. President Johnson vetoes it on the ground that it is unconstitutional. Bingham actually agrees with him that it is unconstitutional. And the principal purpose of the 14th Amendment, not the only purpose, but the principal purpose, was to provide a solid constitutional grounding for the Civil Rights Act of 1866. So when the Congress adds the language of that we see here, that no state may make or enforce any law which can abridge the privileges and immunities of citizens of the United States, that, I think, is shorthand for the rights listed in the 1866 Civil Rights Act, which are identical to the privileges and immunities that were protected to out-of-state citizens under Article 4, which is why the language seems so natural. Now, it may be that this language also was understood by many to protect Bill of Rights rights. I don't actually dispute that. I think that Kurt may well be right about that. But that wasn't the core of it. The core of it, I think, was that, and it may also, Philip may also be right, I think he is, that includes the right to travel, which was a core portion of the Article 4 right, but it doesn't just protect that. It protects within each state that the state of Mississippi may no more discriminate against its own citizens with respect to this set of comity rights than it could discriminate against an out-of-stater with respect to that set of rights. And I think that is the plainest and most natural meaning of the amendment. Now, why don't each of you speak quickly, and we might have time for something from the floor.
Thank you, and it would be wonderful to open this up to a conversation. One point of clarification, as I understand Bingham's reading and what I think was the likely public understanding of the clause as well, is that the privileges or immunities of citizens of the United States included all those rights which were actually listed in the Constitution. That includes Article 4. Article 4 is one of the rights listed in the Constitution and provides sojourning citizens equal access to a limited set of state-conferred rights. So I agree with both Philip and Michael that one of the purposes behind the 14th Amendment was to protect Article 4 equal rights in a way that hadn't been protected before, and to give Congress power to enforce them as well through the addition of Section 5, and that would help constitutionalize the Civil Rights Act of 1866. However, they would not have wanted to transform those equally protected state-conferred rights into substantive national rights of contract, substantive national rights of real estate and marital property and the whole panoply of civil rights in the states. Just to back up a little bit and look at the political context that was going on in the 39th Congress at the time, we've been speaking as if it was a uniform or a unitary body, and of course that isn't true. You know, if you read the work of William Nelson or Earl Maltz or others who have studied this area, you'll see that the 39th Congress was fractured. You had certain radical Republicans who wanted to constitutionalize the entire subject of civil rights through a natural rights kind of reading. You had conservative Republicans who didn't want to do anything. They wanted to minimize any kind of intrusions upon the states. And then you had a middle position represented by people like John Bingham, who wanted to do more than simply protect equal rights. They wanted to protect the Bill of Rights, but they did not want to go as far as the radicals wanted to go. Bingham and the moderates in the 39th Congress insisted on preserving federalism. And this is really kind of an astonishing thing to think about, because why on earth would the members of the 39th Congress be interested in federalism and states' rights? Well, it's because they thought that the slave power had wrongly distorted the original balance between federal and state power. It was the slave power that tried to nationalize slavery and tried to deny the rights of states to free a slave who touched free state soil. So the moderates were trying to do a balancing act, right? They wanted to protect comedy clause rights, but only as a norm of equal protection, and then a certain layer of substantive rights, such as those actually listed in the Constitution. But my reading of the history would suggest that they would not have wanted to have gone further than that and actually nationalize the subject of civil rights altogether.
I'll just say a few words. There's so much here that we don't have time to address. I'll simply point out that the evidence really doesn't match the incorporation thesis. That may be disappointing, but it's the sad reality. And this bill is actually a bit of a problem, isn't it? The privileges and immunities language relates back to comedy clause disputes, as I think is evident from this bill and all the debates that came before it. So that seems to be a bit awkward. What I'd like to do, just in a few minutes, since I think that's all I should take, is just mention when the nationalization of rights really became a popular issue, and that's a little disturbing. We have a very pretty view of history in which there was great evil, and we, reading ourselves back onto the right side, did the right thing, the 14th Amendment, and we've all lived happily ever after since. It doesn't work that way. The nationalization of the Bill of Rights became a popular issue through the work of nativists, native-born Protestant Americans seeking to Americanize American society in opposition to, the Irish, the Catholics, etc. And from the 1870s to the 1940s, they had profound cultural effect in this society, from grade schools up to universities. One of their broadest goals was Americanization of law. They spoke repeatedly about American liberty, not state or federal liberty. And in particular, rather comically, they talk about an American Bill of Rights. It's somewhat hilarious to read their tracts. It includes, by the way, the Ku Klux Klan. And they regularly talk about the American Bill of Rights giving us free speech and various other rights. And any state and federal distinction gets flattened out and wiped away. It's through that sort of propaganda that we actually get common expectations of a uniform Bill of Rights across the United States through what then the court adopts as incorporation. They weren't fond of the nativists, but they were educated in that ethos, and they couldn't help but adopt some of it. In any case, I'll stop there. Thank you.
So we have time for some questions.
I have one. My question is whether it's, is it on? I don't know. Whether it's possible to actually figure this out without also figuring out what the Equal Protection Clause means. Because it seems like everybody agrees something in the 14th Amendment was supposed to stop the black codes, and the temptation for either Kurt's or Philip's view would be to say what was supposed to stop it was the Equal Protection Clause. But then there's a lot of history that suggests that the Equal Protection Clause was supposed to be about protection to physical security. And if that's right, then that puts pressure on the privileges and immunities reading, unless maybe you have some other. So I guess the question is it really possible to pull on one of these three threads?
Well, actually, equal protection is an ancient standard. There's a huge 17th century Dutch and Anglo-Dutch literature on this, and American literature later in the 1770s and 80s. It's a standard of equality dealing with religious differences, and then only later gets adopted as a standard for dealing with differences along lines of race. So three early American constitutions, for example, Maryland and Massachusetts, have equal protection clauses in the 1770s and 80s, right? And it's equal protection as to religious differences. What does this mean? Well, dissenters, minorities, wanted equal rights, i.e., they wanted equality of all rights, both one's natural rights, freedom from constraint, and one's privileges. The establishment comes back, established churches in these states, comes back and says, yes, you're right, you should have equality. We'll give you equal protection, which means equality is to your natural liberty, but not equality as to privileges, i.e. ministerial salaries. So this is a very non-radical vision of equality. But of course, equal protection of one's natural liberty is the very definition of what it is to be free, not to be a slave. This is clear from the literature in the mid-19th century. So the Equal Protection Clause really does deal with unequal constraints, which then leads to a host of other questions we need not pursue here.
And do you have to be right about that? Also be right
Of course not. I think it's an indirect concern, but interesting.
Just briefly, Will, I think you've asked a very difficult question. And it's one that I continue to struggle with. And one of the reasons why I struggle with it is because I'm troubled. I've been unable to join, I think, those scholars who share in Michael's story that sees this, or at least one of the things you spoke of a moment ago, that sees this natural linking of the Civil Rights Act of 1866 and the 14th Amendment. Because they actually were on separate tracks in those early years, in the early months of 1866. You had Bingham introducing his first draft of the 14th Amendment, and then there's a separate introduction of the Civil Rights Act of 1866. Bingham does not support the Civil Rights Act of 1866. He has something else in mind. Now, we can talk about whether or not there was some kind of overlap, whether Bingham intended there to be an overlap or not, but I think that the record is unequivocal that Bingham did not introduce the 14th Amendment as having anything to do with the Civil Rights Act of 1866. Then matters become complicated as you go on. You have Johnson, who then vetoes the Civil Rights Act of 1866. He raises some very interesting concerns. The Civil Rights Act of 1866 started by announcing all persons born are citizens of the United States, and then provides these equal protection norms. Johnson then vetoes it, saying, first of all, these equal protection rights they should all be left to the states. And whether you want to protect them or not, you've also made people citizens. And when you make people citizens, then you are giving them also all the privileges and immunities of citizens of the United States. He distinguishes between the two. Then you get Trumbull and others coming back, and they override the veto, but members of Congress remain troubled as to whether or not they really had the power. So when you get to the second draft of the 14th Amendment, you now have Bingham, you have all the members of Congress, not just John Bingham, but you have several things happening all at once. You have Bingham trying to accomplish his protection of the Bill of Rights. You have those who maybe want to establish a firmer foundation for the Civil Rights Act of 1866. You have some people thinking that the Civil Rights Act of 1866 is fully justified by Article 4 all by itself under a Prigg analysis. Others say, no, it's justified by the 13th Amendment as badges and incidents of slavery. Others saying, no, it's going to be under the 14th Amendment. So it's an extremely complicated and multivariate story as to where exactly in the 14th Amendment, if it is the 14th Amendment, where we justify the Equal Protection Clause. The only thing I'd say, I think it's an important question. I don't think it affects my story of privileges or immunities, but I do think it's something that has not been adequately worked out yet by historians.
Well, I think it's a very revealing question because precisely because somewhere in all of this there has to be a constitutional basis for the Civil Rights Act. And although Kurt is right that a lot of people have all kinds of theories as to how it might have been, that act might have been justified without the 14th Amendment, the fact is that as soon as the 14th Amendment is ratified, one of the very first enforcement act consists of reenacting the Civil Rights Act of 1866 under its authority, which I think is pretty good evidence that that's what they thought they were doing. And I think it's quite clear from the text that the Equal Protection Clause is not the location for doing that. Just the Equal Protection Clause applies to any person within the jurisdiction. The Civil Rights Act of 1866 speaks of citizens, right? Only citizens, and all citizens without regard to race, color, or previous condition of slavery have the same right as white citizens to the enumerated set of rights of the 66 Act. The Equal Protection Clause is not well designed to do that. The Privileges and Immunities Clause is perfectly designed to do that, and it seems to me it's the most compelling explanation of what they were doing.
Well, and if I could just quickly add to that, one of the reasons why Bingham opposed the Civil Rights Act of 1866 was because it only applied to citizens. According to Bingham, who shared the general Republican theory of natural rights, that equal protection was a natural right that belonged to all persons, he said whatever we should be doing, we should be extending equal protection to all persons and not just to citizens. So it's another part of the story.
Right. It actually strikes me that the language of the Civil Rights Act in relationship to citizens actually confirms the problem with the word citizens, obviously, in the Privileges and Immunities Clause. If that's a vehicle for incorporation of the Bill of Rights, which are the rights of, clearly were the rights of persons, not just citizens, there's an awkwardness there, a misdrafting that is difficult to explain given the care that went into this and the prior section, the citizenship definition clause. So,
Ken, one last question.
In the light of this discussion, where would you have the court go now?
You first, Philip.
there are more answers than that than should be said, probably. I'll leave it to you.
Well, just briefly, we're talking about the history, right? I think one of the things that all of us, all three of us here, and certainly the work of Michael and Philip are just exemplars in this regard, is the first thing you want to do is get the history right, okay? And that's where their work has delved so deeply, and it's such a privilege to join them in this conversation. What we do once we get the history clear and what we should do with that original understanding if we're able to identify it, of course, requires a second theory, a question of normative theory as to whether or not you think original understanding should control the current application, the current enforcement of the clause. It's a second issue that would very quickly get us into theories of popular sovereignty and the role of the court and stare decisis. But I would just be on board as saying, let's reverse Slaughterhouse, okay, or reverse Crookshank, excuse me, reverse Crookshank.
Actually, on second thought, I do have something to say on that, which is, I think even if one doesn't believe one side or the other, but just has some doubts about incorporation, one should approach it with a degree of caution. In fact, I think incorporation is a product of certain cultural prejudices that come out of nativism, and that's would be very disturbing, as I think it's true. One thing one might do is think about the costs of incorporation and try to trim back at least a little bit on that. So, for example, incorporation, just taking jury rights as an example, incorporation has a bit of the more is less problem. As you expand access, you end up cutting back in the definition of rights, as also vice versa. Here we're expanding access, so we cut back in the definition, for example, of jury rights. The extension of jury rights to the states led to the reduction of juries, even federal level, sometimes to mere 6. This is awkward. And perhaps we should be very careful about taking limited views of rights simply because we fear they won't be sustained nationally. If one has a clear distinction between state and federal bills of rights and state and federal, and the potential for different interpretations and framings of each, then one can frame one's national rights, the federal bill of rights, in a way that doesn't try to accommodate all the inconveniences that might arise at the state level. So it seems to me there are very great dangers in incorporation when it leads to cutting back then on the rights that are guaranteed, and then that gets reflected in state interpretations following federal interpretations.
And on that note, will you join me in thanking our guests?